the access to family law and guardianship court records?
Yes.
One of these GR 22s of the Supreme Court?
Mm-hmm.
You know, you've allowed an indigent
Yes. Mm-hmm.
petitioner,
Yes.
pro se,
Yeah.
to motion the court for her own dissolution of marriage
Yeah.
without any of the state requirements, without the enforcement of the court rules,
Yes.
without the enforcement of the actual Clallam County court rules,
Yes.
and the Supreme Court of Washington court rules.
Yes.
Now, she would say, well, I paid. I'm in the family.
Yeah.
And in the family, when we pay,
You do what we say.
now these retirement plans that we didn't have because we were indigent,
Yes.
and the $180,000 of debt,
Yes.
and the custody orders of the pro se litigants,
Yes.
known as the petitioner,
Mm-hmm.
where there's no obligation to admit the stipulation and order.
Yes.
You can use forgeries to motion courts,
Yes.
and the judge can't say, well, I can't give you any legal advice.
Yes.
I can't tell you that it's against the law to motion for a default dissolution of marriage when you do get served within the 90 days. I can't tell you that you do have to serve the respondent
Yes.
so as to have proof of service before having court hearings,
Yes.
because as a judge, I can't give you any legal advice. But it looks like judges are just so busy
Yes.
that they just can't take the time to really look at what the pro se litigants,
Yes.
known as petitioners, are submitting to the court as the evidence for the child support, the evidence of the declaration of mailing where I was at 1023 Kitchen Dick Road in September 25th of 2012.
Yes.
The issuance
Right.
of a parenting plan,
Mm-hmm.
temporary order of child support,
Yes.
without an attorney being obligated
Yes.
for any indigent petitioner for dissolution of marriage. See, you made it very difficult for me. I watched you do it because I did look on the state court website.
Yes. Mm-hmm.
And then you had one of these jury hearings,
Right.
where I was at my grandmother's and everybody said he doesn't know. But the indigent petitioner
Yes.
had you issue a dissolution of marriage,
Yeah.
knowing
Yeah.
that we had $180,000 of unsecured debt,
Yes.
knowing
Yes.
that I didn't owe back child support, ouch, because she wasn't here of July
Mm-hmm.
of 2011,
Ouch.
knowing that all the numbers that she had been provided through the state of Washington
Yes.
were completely erroneous because there wasn't enough money for clothing for the 5 minors named. And there's the thought
Yes.
of the United Nations marriage certificate right now, where I'm wanting to get a divorce.
Yes.
And your thought was, well, we're going to deprive you of the honest government services of a judiciary. Now, for the superior courts that get half their income from the county
Yes.
and the other half from the state,
Yeah.
I'm suing you for violating your own court rules. And
Ouch.
in every superior court right now, I'm suing the state for refusing to obligate
Yes.
idiot litigants known as petitioners to not have to have an attorney represent them. See, if you had one of these notice for trial setting, settlement, conference setting hearings,
Yes. Yes. Yes.
proposed parenting plan, child support motion, and affidavit of declaration,
Yeah.
notice of the hearing,
Yeah.
settlement conference setting hearing, I'd be one of those that would call their attorney
Yes.
because I can talk to their attorney and ask, why didn't you give me notice? Now, their attorney could lie,
Yes.
but I could file a complaint with the Bar Association of official misconduct of the individual representing the petitioner. But when there is no way that I have any right